Welcome to the court proceedings discussion in my Florida Baker Act educational series. I am going to provide some details about how the legal system works in favor of the patient when they are on involuntary status, aka under the Baker Act. When a petition is filed, the patient will be seen by a public defender regardless of income. So let's be clear. Each and every individual under a Baker Act has immediate access to the already assigned public defender. Therefore, seeking representation of a private attorney is just costly and simply unnecessary. They can't do anything more than the public defender can do, period. Each receiving facility across the state of Florida has an already assigned public defender that only handles Baker Acts. And they only handle the Baker Acts for the facilities that they are assigned to. Here's how the petition works. It has to be filed before the 72 hours expires. If it is not, the facility is then continuing to hold a patient against their will, which is in violation of the Florida statutes. Now, in a less than reputable facility, if a patient declines to sign the voluntary before the 72-hour expiration, the petition will most likely be filed. Because remember, in this type of facility, they are more interested in getting paid for that third day. Now, the facility's intent to discharge the patient on the fourth day may be dependent on the patient's insurance coverage, which they obviously aren't going to share with the patient. I mean, they aren't going to say to the patient, hey, your insurance actually only covers for 3 days, so you're definitely going home tomorrow. Or that, hey, your insurance coverage is for like 7 days, so we're going to see how we can keep you here for those 7 days. They're not going to do that. So if the patient signs voluntary, this actually releases the facility of their responsibility to adhere to certain statutory requirements. The time frames for involuntary patients are stricter than for those patients that are allegedly willingly consenting to treatment. The facility can then manipulate the length of stay based on what they determine is appropriate for the patient. When a patient learns that they're not getting released in the 72 hours, they usually get upset and or angry, reasonably so. The typical underlying emotion of anger is fear. So now, in this situation, what could the patient possibly be fearful of? I don't know. Maybe not getting discharged or released or being able to go home. The patient is now in fear of being held involuntarily for an unknown period of time. In order to overcome that fear, they usually end up signing voluntary. More times than not, this actually results in extending their stay a minimum of 2 days. I witnessed patients being told that filling out a writ would extend their stay and it would be better to sign voluntary. That is not accurate. This fear tactic is successful because the hearing can take up to 5 business days to be scheduled. Let me provide you a little bit of information before I help you process a little bit more about what I'm sharing. When a petition is filed, a hearing must be held within 5 business days, and one of the professionals that executed the petition must be a witness, which is typically the psychiatrist, and then the hearing is held at the facility. Let's say for now that the hearing occurs. If there is clear and convincing evidence that a person meets criteria for continued involuntary commitment, the person could be committed to a mental health facility for up to 6 months. Reason enough to be fearful, right? Absolutely. Okay, so now let's calm that fear. First, I am not an attorney and I am not providing any legal advice. Second, psychiatrists do not want to spend their time testifying. Lastly, and most importantly, clear and convincing evidence is required for an order for a person to continue to be held against their will. Now, clear and convincing evidence is a medium level of burden of proof, which is higher than a preponderance of evidence and less than beyond a reasonable doubt. So in this situation, the facility or psychiatrist would have to prove that the patient is substantially more likely to kill themselves or someone else than not. Basically, a patient would have to be actively making statements or demonstrating that they want to harm themselves or someone else. Also, logically, if a facility's concern is financial, do you think that they are going to proceed to a costly hearing when they are most likely not going to prevail? No. So, please don't allow yourself and or a family member be manipulated through fear. A less than reputable facility will usually file a petition, 1, to cover their rear end, or 2, to buy at minimum 5 days based on the insurance coverage. You may be wondering, what is the public defender's role? Well, here's your answer. The public defender's responsibility is to represent the patient. So even if the public defender thinks that the patient should stay at the facility, yet the patient says that they want to go home and they want to be released, the public defender must file a petition for discharge. The public defender is the patient's advocate. The patient and or a loved one should access this individual immediately by filling out a writ within the first 24 hours and do not sign voluntary. Once the petition is approved and the court order is signed, the patient must be discharged immediately. Thank you for watching. I appreciate the subscriptions and the likes. Please keep clicking those buttons, and please share these videos with your family and your friends. Help me to spread the word and put a stop to these shenanigans. Until next week, thanks again, and I wish for each of you to be strong and be well.